Justice Department's attempt to extradite the Gupta brothers from the United Arab Emirates has failed on a technicality. A court in the country found that the United Arab Emirates has jurisdiction over the money laundering charge. Even more, the decision was taken in February already. The Justice Department was only informed about it this week. Atul and Rajesh Gupta are accused of being architects of state capture and of profiting from their close links with former President Jacob Zuma. After fleeing South Africa, they were arrested in the UAE in June 2022. Government says it was caught off guard and will engage its counterparts in the UAE to ensure the dismissal is appealed. eNCA's Silindelo Masikane has the details and joins me now from Durban. Slee, can you give us a summary of what came out of that briefing with Minister Ronald Lamola today?
Well, in essence, Anli, we saw the minister as well as the NDPP as well as the Director General of the Justice Department going through the timeline of how this process unfolded. You would remember that last year in February, we saw Interpol issuing a red notice for the Gupta brothers. That subsequently led to their arrest, like you said, in June. And South Africa then began its application to have them extradited in July. The statement that was read out went into detail about the meetings that happened, how said the central authority had given them the go-ahead to say that their application should be successful, essentially, and that there was nothing wrong with it, only to find out from what we heard in the briefing that the minister and authorities only found out yesterday that there was already a court hearing which had concluded without any South African representative or authority there for those proceedings, and that the extradition was essentially denied on, like you said, a technicality with regards to the charges. That's money laundering as well as fraud. And in terms of the money laundering charge, the UAE gave the reason that they had the jurisdiction to actually prosecute on that particular charge. And with the fraud charge, they said that there was an issue with the warrant of arrest, and that they were in possession of proof or facts around the fact that it was cancelled. So the minister was actually conveying his shock, his dismay, to quote him, saying that, in terms of the treaty between the two countries, South Africa should have had been given an opportunity to actually, correct or clarify what they may have perceived to be an issue with the application. Let's take a look at
our side. And the central authority, the department and everything, we have complied with every letter of the extradition treaty that we have between ourselves and the UAE authorities. And to ensure this compliance, as the NDPP and the DG have said, we have even sent the central authority and allowed also the NPA to go to the UAE to have engagements with their counterparts. Before the papers were submitted, they said the central authority in the UAE and the prosecution in the UAE confirmed that all our papers are in order. So from our side, we have complied. And that's why we are bemused by this judgment that cites technicalities. And we find it shocking that such a technicality has been cited when all these efforts have been put by us. And that's why I went through the timelines of what we did and what happened between our central authority and the central authorities of the UAE. But as I read Article 17 of the United Nations Convention Against Corruption, even if that was the case, the authority, even if they had the technicality problems, the authorities in the UAE, in terms of this Article 17, should have still required clarity from our authorities that there is this issue, for example, of the warrant that was cancelled, which could have been easily explained by the NDPP as she's explaining now to them, because the correct warrant is still there. They could have been able to get clarity. So Article 17 of the United Nations Convention, maybe I should read it again. It says that before refusing extradition, the requested state party shall, where appropriate, consult with the requesting state party to provide it with ample opportunity to present its opinions and to provide information relevant to its allegation. So there is no basis whatsoever for this technical judgment that we have been given. So from our side, we are still very clear that we complied with the treaty and its obligations.
Slee, today we've heard scathing criticism of the Department of Justice and the NDPP for their failure to secure extradition of the Guptas. What does the NDPP have to say?
Well, she in essence was reassuring the nation. I would, get from her, the sense I got from her was that they are still committed to trying to get the Gupta brothers back, as well as all those who are implicated in state capture. And she was saying that, she believes they dotted their I's, they crossed their T's, but they will continue to try again. They are planning on appealing this decision. And like you said, a lot of criticism around how this process has been handled. Let's take a listen.
I would have thought that the statement, as well as what the those of us on this panel have mentioned today, would have been absolutely clear about the fact that South Africa ticked all the boxes and did everything that was required to ensure that our extradition had the best possible opportunities for successful application. There was nothing more that the South African authorities could have done. That's the first thing. And I think it's very important for colleagues to understand these processes and the way they work. The second issue on this is that, what are the chances of the Guptas ever being brought? It's a question of, how long is a piece of string, really? We don't know. It depends on a whole lot. Extradition is a complicated process. And when there are persons that are trying to make sure that they do not ever face justice, rest assured, corruption fights back. And they're going to fight back with every possible means and opportunities to ensure that they are never brought back to stand trial in South Africa, because they understand what the consequences will be. So all I can say is that, depending on the countries that you're dealing with, some processes are, as the DG explains, could be less complicated than others. So at the end of the day, we have to ensure that as a country, irrespective of where they are, we do everything possible to ensure that they are brought back to face justice in South Africa. It is what the people of this country expect and want. It is what we, as those in the criminal justice system, want and expect. So we will leave no stone unturned.
Slee, while we were getting updates on prosecutions, did Minister Lamola give us any update on the situation regarding Thabo Bester?
No, authorities remain quite tight-lipped with regards to investigations with, the manhunt for Thabo Bester as well as his accomplices. We know that we're expecting a parliamentary sitting, the Portfolio Committee for Justice and Correctional Services. They have summoned G4S Security. Of course, that's the private security company that was running Mangaung Prison when the escape happened. Subsequently, Correctional Services has taken over the running of the prison by invoking Section 112 of the Correctional Services Act. So, we tried to pose some questions to the minister, but he simply said that, all the answers would be given next week during that sitting of the Portfolio Committee. Let's take a listen.
With regards to the one of Thabo Bester, I think Crispin has outlined. We are going to go back to the Portfolio Committee, and we will further give any further update that is necessary, except to confirm that indeed there is work by the South African police and also by correctional services to recapture him. And all the people of interest are being looked at. And at the right time, I believe the police will be able to give an update.
Well, thank you very much, Silindelo Masikane, senior eNCA reporter, giving us an update there from Durban.